Hello, my name is Paul Geyer, and I'm here to chat with you today about ethical issues in forensic engineering. This is what I will be talking about today. Professional engineers who have reached mid-career may have heard the term forensic engineer, but may not know much about what a forensic engineer does. This is because forensic engineering is not an engineering discipline, but it's a business enterprise connected to the legal industry in the United States. It is an enterprise that challenges the public and practicing professional engineers. Forensic engineering is a business enterprise in which a relatively small number of professional engineers engage. Its proponents say it seeks to improve the quality of engineering, but others say some of the participants are interested only in self-gain. Its critics say forensic engineers, in many cases, use specious claims and the legal system in the United States to extort unwarranted settlement payments from other professional engineers, private companies, and public agencies. This discussion looks at the social, legal, and human factors that underpin the forensic engineering business. It suggests an approach to neutralizing those who engage in forensic engineering for self-gain, rather than in search of just conclusions. This is how I'll be chopping up the information, sort of the chapters in the book today. Some introductory comments. Then, what is forensic engineering? Third, framing the ethical issues. And then some background information, something about systems of law in the United States and throughout the world. Then a little bit of sociology or psychology for you. A discussion of the difference between linear and nonlinear thinkers. Sixth, a discussion of materialism. All three of these discussions, systems of law, linear and nonlinear thinkers, and materialism, I believe are important to understanding the people that are engaged in what is termed the forensic engineering business. So then we can look at what are the ethical issues, and then resolving those ethical issues. How can we resolve them? By way of introduction, this tells you a little bit about what I've been doing for the last few decades. And since a lot of what we're going to be talking about today has to do with the legal system in this country, it's probably worth taking note of the fact that in addition to my engineering training, I also spent 3 years in law school and had the pleasure of learning a little bit about the legal system in this country. Now, what is forensic engineering? Well, here are some definitions from different sources. Now, these are actual quotes that I just really came across with minimal Googling. These are not my words. These are the words of whoever posted the information on the internet. Forensic engineering is the investigation of materials, products, structures, or components that fail or do not operate or function as intended, causing personal injury or damage to property. The consequences of failure are dealt with by the law of product liability. So we see the legal system creeping in. The application of accepted engineering practices and principles for discussion, debate, argumentative, or legal purposes. More legal system oozing in under the doorstop. Application of engineering methods in determination and interpretation of causes of damage to or failure of equipment, machines, or structures. Damages, legal system, yes, okay. Forensic engineering is defined as the application of the art and science of engineering in matters which are in or may possibly relate to the jurisprudence system, the legal system, inclusive of alternative dispute resolution. More, forensic engineering is the application of the art and science of engineering to the jurisprudence system, the legal system again, requiring the services of legally qualified professional engineers. Forensic engineering may include the investigation of the physical causes of accidents and other sources of claims and litigation, preparation of engineering reports, testimony at hearings and trials in administrative or judicial proceedings, and the rendition of advisory opinion to assist in the resolution of disputes affecting life or property. More, legal system. Forensic engineering is the application of engineering principles to the investigation of failures or other performance problems. Forensic engineering also involves testimony on the findings of these investigations before a court of law or other judicial forum when required. So I think these quotations paint a pretty clear picture. Forensic engineering is not an engineering discipline. Engineering is the art and science of applied physics. Training and practice in engineering is, for obvious reasons, structured consistent with the principles of physics. For example, electrical engineering is the art and science of application of the physical principles of electricity. Mechanical engineering is the application of the physical principles of mechanics, and so forth. But there are no physical principles of, quote, forensics, end quote. The conclusion that I have reached, and I think that it's appropriate, is that forensic engineering is a business enterprise. The objective of its practitioners is mercantile, that is, to make money with which to buy the goods and services that will allow them to lead a secure, comfortable, and enriching life. Nothing wrong with that. That's human nature. This is the reason people seek out and pursue jobs and careers. This is all perfectly reasonable. So I would suggest to you that forensic engineering is an appendage of the legal system in the United States. Forensic engineers are participants in the legal system in the United States. This is clear from the preceding quotations and many other sources. For example, such words as the law of product liability or legal purposes, interpretation of causes of damage, the jurisprudence system, application of the art and science of engineering in the jurisprudence system of these investigations before a court of law or other judicial forum. To address the ethical issues presented by a forensic engineer in a formal legal system in the United States, what is called the common law system, it will be helpful to describe the actors in a legal dispute generically and in customary common law terminology, and B, the possible just and unjust outcomes that may result from the actions of a forensic engineer. Table 3.1 is a framework for the actors in the formal legal dispute resolution system that we have in this country. Table 3.2 is a framework for the possible just and unjust outcomes that may result from the actions of a forensic engineer. Table 3 summarizes in generic terms the actors in a formal legal system. You have a judicial authority, that's the judge and possibly a jury if it's a jury trial. The accusing party called the plaintiff. Then the legal system in the United States is such that it is completely inaccessible de facto unless you pay a lawyer, an advocate, to represent you. That advocate is called a lawyer. And so a plaintiff who is undertaking to obtain money from a defendant hires an advocate or lawyer, uh, and at the lawyer's behest, he will most likely also be hiring expert witnesses, which can include a forensic engineer. And then the defendant, as a result of being sued in the legal system in this country, is forced to pay a lawyer to represent him and to pay for expert witnesses that may include a forensic. And you can have two kinds of results that come out of a legal proceeding. Uh, One result that is just. By that I mean fair, equitable, it's reasonable. And then one that is unjust. And the function of lawyers and forensic engineers and other expert witnesses is to present information to the judicial authority that will convince them to find in favor of either of their client, either a plaintiff or a defendant, without any regard to what in truth and in fact is just or fair. Now, as background to this discussion, I want to talk about three social constructs that I think it's important to have in the back of one's mind when talking about this issue. And these, of course, have nothing to do with engineering as such, but they tell us something about the way people behave in the real world, the way judges behave, the way lawyers behave, the way expert witnesses behave, the way forensic engineers behave. And the three social constructs are systems of law, the kind of sociological construct of linear and nonlinear thinkers, and then the materialism, the way it has been represented in the literature, I think will help us to address. So let's look first at the systems of law that exist in the world today. There is something called the civil law, which originated with the Romans. There is the common law, which originated with our good friends in Great Britain. And there is Islamic law, which is an Eastern form of law that exists, as we are reading more and more about in the papers these days, in the Middle East and in North Africa. And this map here shows where these systems of law exist in the world. You see the largest, at least from an area standpoint, and probably from certainly from a population standpoint, the largest number of people in the world are under the provisions of civil law, that which came down from the Romans. And then you see, and those are the blue areas, of course, in this map, this figure. And then there are the common law jurisdictions, which are kind of the reddish brown color. And you see a little teeny tiny blob up there, kind of in the center, upper center, and that's where it all got started with our good friends in England. And you see the countries where this system of law, common law, is currently the law of the land. India, Australia, the United States and Canada, and then a few African countries. And then you see something called bijuridical, which is a dark brown, and then the Islamic, which is kind of the yellowish brown. Well, the Islamic law we're going to just set aside because it's the uh, the authority for the law is a religious figure. The judge, jury, and executioner is a religious entity or figure. And it's just not relevant to what we're talking about here with forensic engineering in a common law environment. But you can see from this map that where these systems of law have migrated to is a result of essentially colonization. The Romans conquered a lot of Europe, and the countries then in Europe adopted the civil law, and then through colonization by those European countries, France, Germany, Italy, Portugal, Spain, it spread to Africa and to South America. And then you see with the reddish brown colors there that the British took their common law system where they, in the places where they colonized, India, Australia, the United States, Canada, and a few countries in Africa. Then there's bijuridical, which is kind of a brown color, and that's really where colonization was a conflicting exercise. There were countries, one or more countries, that came from a civil law tradition in conflict with a country, Great Britain, that came from the common law system. And so these areas where this kind of colonization took place, you got kind of a mixed bag of a combination of civil and common law. The few countries there at the southern tip of Africa, and then in Quebec, where the French and the British were in conflict. And so these are the systems of law. And in the civil law, it is the most widespread system of law in the world. Again, this is the system of law that we do not have in the United States, and it is the system of law that has come down to the world via the Romans, essentially. So under civil law of the land is enunciated and approved by a duly constituted governmental body of appropriate authority, a parliament, a congress, a legislature, yes, an emperor, and other monarchical types of authorities. But the law was enunciated by a governmental body of appropriate authority, maybe not one that everybody was in love with, but still an appropriate authority. And it was codified. That means written down in a book, published in print. And so if you want to know what the law is, you go to a book and you read it. And in there it says, "Thou shalt not steal." And that's the law, period, end of story. What is in the book? Now, there are two important distinguishing characteristics about civil law. The law, first of all, the law is established and enunciated, written down by an appropriately established governmental body, a parliament, congress, legislature, emperor, not by the exercise of the prerogative of individual judges. That's very, very important. In the civil law system, the judge is responsible for reaching a just conclusion. In this pursuit, the judge in a civil law system has at his disposal the resources, such as investigators, needed to discover facts so as to reach a just conclusion. Now, I do not want to tell you that judges in the civil law system are these perfect human beings and that they don't allow their own prejudices to enter into the rendering of their decisions. But fundamentally, from the the civil law as it has come down from the Romans, the judge has a responsibility to determine the truth and to he has the resources to investigate, to determine the truth, and then he has a responsibility to, under the civil law system, to reach a just, fair, equitable conclusion. And so he has the responsibility to compel the presence of and to interrogate witnesses, demand the production of documentary evidence, and to order court investigators to investigate, discover, and report facts that are needed for the judge to reach a just conclusion. This writing down of the law, of the civil law, codification, is considered to have begun with the Code of Hammurabi in Babylon around 1790 BC, and civil law systems developed during the Roman Empire. And today, civil law is interpreted rather than developed or made by judges. Only legislative enactments rather than legal precedents, that is, the personal opinions of judges, as is in common law, are considered legally binding. And this is very important. Now we have the common law. It's less prevalent than the civil law in the world. Under common law, the law of the land may or may not have originally been enunciated and approved by a duly constituted governmental body of appropriate authority. There are two important distinguishing characteristics of common law. In common law, the law may be established and enunciated, written down, by an appropriately established governmental body, just as in the civil law system, enunciated by a parliament, congress, legislature, emperor, king. But in addition, the law is established under the common law system by pronouncements by individual judges acting on their own volition and representing their personal opinions of right and wrong and what the decisions should be. Also, very importantly, in the common law system, the judge is not responsible for reaching a just conclusion. The role of the judge and the jury is to listen to the arguments presented by advocates for the plaintiff and the defendant, and then make a decision which party is to prevail. But he has no responsibility to make a decision that is just, fair, and equitable. And he can make a decision that reflects his personal opinions. It can reflect whether he likes the plaintiff better than the defendant. He has complete freedom to do this, and that is the way it is done in the common law system. The common law was developed in England, and it was inherited by the English Commonwealth of Nations, countries colonized by England, including the United States. And almost every colony of the British Empire has adopted it. The doctrine of what's called, if you're into Latin, it's called stare decisis, or precedent by courts, that is, judges, is the major difference between common law and the codified civil law. So in the common law system, you have in reality two sources of the law: that which is duly enacted by an appropriate governmental authority, a legislature, etc., etc. But then you have an absolutely massive body of, quote, case law, which is just personal opinions of judges. And then the Islamic law, but again, we're setting that aside because that is a different kettle of fish, a part of the world that we're just not that involved in here in the West. That's a way of characterizing it. That's an Eastern form of law compared to the Western forms. So anyway, Islamic law is a system where the law of the land has been enunciated and is enforced by religious authorities based on religious dogma. These religious authorities are not elected or appointed to their offices through any secular government mechanisms such as popular elections and appointments. Islamic law's application is generally confined to the Middle East and North Africa. It's culturally an Eastern legal system. The U.S., which is the focus of this discussion, is a Western civilization, and the culturally Western legal systems, civil law and common law, are of interest here. So we will therefore set Islamic law aside from this point forward. So here in this table is what I feel is a summary of the differences between the civil law system and the common law system, which we are blessed with here in the United States. Um, the consideration, the law of the land is enunciated by, under the civil law, a duly established governmental body. Under common law, it also may be established by a governmental body, but in addition, individual judges, based on their personal interpretations of the law, uh, have created this massive body of what is called case law. The next consideration, the judicial authority, the judge and or jury, is charged for responsibility for, under the civil law, reaching a just conclusion. Under the common law, the judge and the jury simply listen to the arguments and evidence presented by the accusing party and the accused party, and making a decision favoring one party or the other based on those arguments and evidence, with no responsibility for reaching a just conclusion, in my view. The next consideration, the judicial authority has responsibility and resources to investigate the matter in order to determine the truth and reach a just judgment. Under the civil law, yes. Under common law, no. The judicial authority has a responsibility to interrogate witnesses in order to determine the truth of the matter and reach a just conclusion. Under the civil law system, yes. Under the common law system, no. Another consideration is that advocates, lawyers, and expert witnesses, like forensic engineers, are effectively bound to provide complete and unbiased evidence and testimony. Under the civil law system, yes. Under the common law system, no. Advocates and their expert witnesses are bound to present only testimony and evidence that supports the position of their client, including that which is limited, biased, and false. And finally, representative countries and regions where the system is the law of the land are what we already saw on the map. The civil law covers the largest quantity of civilization on this particular planet, significantly more in terms of geographical spread as well as populations than the common law system. Well, so what does this tell us about the common law system in the U.S.? Well, I came across something a while back that I thought really hit the nail on the head, and it was a popular fiction thriller book by a very well-known New York Times best-selling author, a gentleman named Michael Connelly, who specializes in crime and legal thrillers. Very popular writer, and many of you may be familiar with him. And in one of his recent books called The Brass Verdict, on page 1 of that book, I think he hit the nail on the head about the legal system in the United States. And these are his words. This is an exact quote. on the first page of this book. Everybody lies. Cops lie, lawyers lie, witnesses lie, the victims lie. A trial is a contest of lies, and everybody in the courtroom knows this. The judge knows this, even the jury knows this. They come into the courtroom, into the building, knowing they will be lied to you. And I would suggest to you that forensic engineers, falling into the category of expert witnesses, are paid to lie. Now, that doesn't mean that they may not say things that are true, or that the lying is very overt. It can be lying by an omission, telling partial truths. So what does this tell us about a common law legal system? First, the judicial authority, the judge and or the jury, is responsible only for listening to arguments and considering evidence and testimony presented by advocates, lawyers, and expert witnesses, forensic engineers, and rendering a judgment thereupon in consideration of the law of the land as previously enunciated by legislative bodies and other judges. Advocates, lawyers, and expert witnesses, such as forensic engineers, are not compelled to provide complete and unbiased testimony and evidence. To the contrary, it's common practice for advocates and expert witnesses to present evidence and testimony to the judicial authority that is incomplete and biased in furtherance of the interests of their client. Since the judicial authority has no responsibility to ascertain the truth of the matter, advocates and expert witnesses have the flexibility to present evidence and testimony that is not true in furtherance of the interests of their client. The judicial authority has no responsibility and resources to investigate and determine into the completeness, absence of bias, and truthfulness of evidence and testimony presented by advocates and expert witnesses. Now let's look at the second of these social constructs, that concept being of linear and nonlinear thinkers. A linear thinker is driven by rules. When presented with an issue, they apply universally accepted rules and reason logically to a conclusion that is driven by those rules. Engineers are classic examples of linear thinkers. Professional engineers are trained in engineering schools in the irrefutable laws of applied physics and learn to apply those laws to engineering problems in order to arrive at a correct solution. In engineering practice, professional engineers are even more intensively driven by rules in the form of numerous codes, regulations, and design guides. Engineers are not the only examples of linear thinkers. Medical doctors, scientists, and accountants are some other examples of linear thinkers. Here is a picture of how a linear thinker, such as an engineer, gets from a problem, point A, to a solution, point B. A linear thinker arrives at point B by logical application of rules, not because point B is a predetermined goal. But this is not how nonlinear thinkers get from point A to perhaps point B, or point C, or point D, depending on which is his or her goal. Nonlinear thinkers are not concerned about rules. They're concerned about getting from point A to point C. Point A is the situation with which they are currently confronted, and point C is where they want to be. They are goal-oriented. For example, if a nonlinear thinker is currently a clerk in the mailroom of a large corporation, point A, his goal may be to become chief executive officer of that large corporation, point C. His goal is not to design a big bridge, point B. He wants to be chief executive officer of that large corporation, point C. Here is a picture of how a nonlinear thinker gets from where he is now to where he wants to be, Point C. Typical linear thinkers are professional engineers, scientists, medical doctors, accountants. Typical nonlinear thinkers are lawyers, politicians, salesmen, artists. Now let's look at the third of these social constructs, materialism. The highest priorities of people are materialistic. People are driven to acquire the material things that bring them security, comfort, pleasure, and esteem from their peers. The most famous articulation of human needs was by psychologist Abraham Maslow in 1943. His theory is known as Maslow's hierarchy of needs and is widely accepted today as credible. It's frequently represented by a pyramid with the highest priority needs at the base and the lowest at the top, thus providing a graphic quantification of what considerations people value most and devote the most energy to obtaining. See Figure 6.1. At the bottom are the psychological needs of breathing, food, water, sex, sleep, homeostasis, etc. Next level up is those for safety, security of body, employment, resources, morality, the family. Little higher up, love and belonging, friendship, family. Esteem is the next level up, self-esteem, confidence, achievement, respect of others. And at the very top, morality, creativity, spontaneity, lack of prejudice, in other words, justice. And it is the needs that are at the bottom of Maslow's hierarchy of needs that people devote their time and energy to, and they only move up the pyramid typically once they have satisfied those needs at the lower level. Notice that people value most highly food and water, resources, property. In mercantile cultures, the mechanism that has been developed to facilitate trading and exchange for these highly valued temporal desires is money. Money is the medium people devote much of their energy to obtaining so they can exchange it for material things that will satisfy their desire for security, comfort, pleasure, and esteem. As an example, legal systems that have developed over eons purport to satisfy higher level human needs, such as morality, problem solving, lack of prejudice, acceptance of facts. There is, however, an inherent conflict with legal systems, such as common law, in mercantile cultures, such as in the United States and elsewhere. The common law legal system nominally strives for morality, problem solving, lack of prejudice, and acceptance of facts, but the primary motivation of the humans, lawyers, and note that all judges are lawyers, and expert witnesses as well, engaged in the common law legal system as a mercantile enterprise is to acquire money which can be exchanged for food and water, resources, property. This conflict is the root of the ethical issues inherent in the business of forensic engineering. The root of the ethical issue in forensic engineering is the conflict between the high-level objectives of a legal system and the basic objectives of the humans engaged in the legal system as a mercantile enterprise. Lawyers, of course, are the primary participants in a legal system. Indeed, in a common law culture such as that in the United States, the caricature of avaricious lawyers doing everything possible to make money from the legal system is likely not too far from the truth. This is consistent with the psychological profile of lawyers as nonlinear thinkers. They are willing to do almost anything regardless of moral and ethical rules to achieve their goal of making money. This is also consistent with the role of lawyers in a common law legal system. A lawyer in the common law legal system is an advocate for his client. He has no responsibility to present evidence and testimony to the judicial authority that is complete, unbiased, and true. Indeed, a lawyer is free to present evidence and testimony that is incomplete, biased, and untrue. And because of mercantile considerations, clients are unlikely to return to, and prospective clients are unlikely to engage lawyers who lose cases. It therefore is not unreasonable to expect lawyers to do whatever is possible short of going to jail to win cases, and this may well entail presenting evidence and testimony to a judicial authority that is incomplete, biased, and untrue. Expert witnesses include those engaged in forensic engineering. These forensic engineers are subject to the same mercantile forces as lawyers. They are technical advocates for a specific client. In a common law legal system, they are free to present evidence and testimony to a judicial authority that is incomplete, biased, and untrue in pursuit of their client's interests. They are also aware that forensic engineers who provide evidence and testimony to a judicial authority which does not result in a judgment that is favorable to the forensic engineer's client are unlikely to receive repeat business from that client, and prospective clients will question the wisdom of retaining them in the future. This then is the fundamental issue present in forensic engineering. How can the public and the engineering profession assure that the mercantile interests of professional engineers engaged in the forensic engineering business do not move them to provide incomplete, biased, and false technical evidence and testimony to judicial authorities that unjustly damages persons, companies, and agencies? These are the ways business and professional behavior of individuals may be influenced: moral suasion, professional censure, government regulation, legal proscription, and mercantile persuasion. First, moral suasion, which can take many forms, but all involve an appeal to the higher human need of morality. In some way, methods of moral suasion all amount to preaching that the undesirable behavior is bad. This might be an approach in an Eastern culture under Islamic law, but in a Western mercantile culture, the strong fundamental human need to make money is going to override the higher human need of morality. Moral suasion is unlikely to prevent a professional engineer whose livelihood is derived from the business enterprise of forensic engineering from presenting incomplete, biased, and false evidence and testimony to a judicial authority in furtherance of his client's interest. The only thing less likely would be moral suasion influencing a lawyer engaged in the business enterprise of practicing the law to not present incomplete, biased, and false evidence and testimony to a judicial authority in furtherance of his client's interest. With moral suasion, one is attempting to influence the behavior of a person by appealing to the high-level morality human needs, when the person that you are attempting to influence is not interested in those higher level needs, but is interested only in the lower level physiological safety, mercantile, making money needs. Professional censure. Professional engineering societies are weak compared to, say, bar associations, which are strong. If a certain type of behavior of its lawyer members is proscribed by a bar association typically has the power to prevent a transgressing member from engaging in the business of practicing the law. This is an effective censure because it prevents the lawyer member from satisfying his most basic need, which is to make money. Professional engineering societies have no such power to prevent an engineer member from satisfying the basic human need to make money. Indeed, membership in professional engineering societies is completely voluntary and rather spotty at best. There is no scenario that can be envisioned where censure by a professional engineering society would be effective in modifying a professional engineer's behavior. With professional censure, one is attempting to influence someone, a forensic engineer, by appealing to the esteem needs, but the forensic engineer is not interested in esteem. He or she is interested in making money to satisfy the lower level physiological safety and perhaps love belonging needs. Government regulation. The ability of some engineers to satisfy their basic human need to make money can be controlled by government regulation, specifically by engineering registration boards. The power of registration boards to control behavior of engineers, however, applies to only a small segment of the engineering profession in the United States. It applies only to those engineers who seek to use the title professional engineer and offer their services directly to the public. The vast majority of well-qualified engineers in the United States, however, are employed by companies and agencies which are exempt from professional engineering registration laws, and engineers employed by them are not required to be registered as a matter of law. An additional complicating factor is motivating engineering registration board bureaucracies to take action on a matter such as this. It might be said that government bureaucracies have a high moment of inertia. So again, the remedy is not going to be effective because of the inefficiency of bureaucracies and the fact that only a very small percentage of the engineers in the United States are registered with a government agency or registration. Additionally, because governmental action would be required, any attempt to prevent forensic engineers from presenting evidence and testimony to judicial authorities that is incomplete, biased, and untrue would be opposed by lawyers' lobbyists. This opposition would arise because the fundamental strategy of lawyers is to prevent evidence, testimony, and arguments to judicial authorities that is incomplete, biased, and untrue when it is in furtherance of a client's interest. Given the proven power of lawyers' lobbyists to influence governmental bodies throughout the 50 states and in Washington, D.C., this would be a formidable barrier to legal proscription, where judicial authorities, judges, to enunciate that forensic engineers must not provide testimony and evidence that is incomplete, biased, and untrue. And if the judicial authorities enforce these proscriptions with meaningful penalties such as contempt citations with mandatory incarceration, proscription within the legal system might be effective. This could, however, only be effective under a system of civil law wherein the judicial authority, the judge, and lawyers have a responsibility to investigate and reach a just judgment. Under common law, the judicial authority, the judge and the jury, has no responsibility to arrive at a just judgment. The judicial authority's only responsibility is to listen to the evidence, testimony, and arguments of the opposing advocates, which may be incomplete, biased, and untrue, and thereupon render a judgment favoring one party or the other. Legal proscription will never remedy this ethical failure because of the fundamental nature of the common law system and the fealty and economic investment judges and lawyers in the United States and other common law countries have in it. Mercantile persuasion. Here there may be an answer. Forensic engineers are motivated for mercantile reasons to present evidence and testimony to judicial authorities that is incomplete, biased, and untrue if it advances the interests of their clients. But the same common law mechanisms may be used to motivate forensic engineers to present only evidence and testimony to judicial authorities that is complete, unbiased, and true, and that is the threat of being sued. This will be addressing the forensic engineer at the fundamental level of his needs, his or her needs, physiological safety, etc., etc. And this may be effective in modifying his. The common law system, legal system, is a mercantile system. It's developed over centuries as a mercantile system to benefit its primary participants, advocates, lawyers. De facto, the common law's pretense to be a system for delivering justice is inconsequential. Here is how the mercantile system works. The cost to make a claim against another party to file a lawsuit is minuscule, perhaps a few $100s. Once a party is sued, the accused party is compelled to hire a lawyer. In theory, an accused party could go before a judicial authority and present his own evidence, testimony, and arguments, but this will never succeed because if it did, there would be no mercantile opportunities for advocates, lawyers. Judicial authorities, judges, would never allow this to happen because judicial authorities, judges, have the same basic human need to make money as advocates, lawyers, and judicial authorities, judges, are just advocates, lawyers, in different clothing. Having been sued, the accused party is subject to extortionate economic pressures. The accused is compelled by the common law mercantile system to hire an advocate, a lawyer. If the accused party does not hire an advocate, a lawyer, the common law is enunciated such that the accused party is automatically liable to the accusing party for whatever amount of compensation the accusing party elects to claim, without any determination of right or wrong. The accusing party is compelled to hire an advocate, a lawyer, who is free to charge hourly rates and fictitiously claim hours of work, all out of proportion to the value of the advocate's services. The cost for an accusing party to make a specious claim, file a lawsuit, is minuscule, but the cost for the accused party to defend himself is massive. Out of fear of the cost of defense, the accused party submits to the accusing party's demands. Thus, an accused party is forced by economic necessity to pay an unjustified amount to settle an unwarranted claim, which includes outsized compensation for the accusing party's advocate, lawyer. This is how the extortionate pressures work on the accused party. But now, let me make a modest proposal. To resolve the ethical issue, employ lawsuits against forensic engineers to neutralize those who use the legal system for egregious mercantile purposes. The cost to file a lawsuit against a forensic engineer is minimal. There are many arguable causes for legal action: defamation, libel, slander, fraud, interference with business relationships, abuse of legal process, perjury, etc., etc. Filing a lawsuit against a forensic engineer who uses the legal system for egregiously mercantile purposes will, as the saying goes, put the shoe on the other foot. The accused forensic engineer will be subjected to the same extortionate costs of legal defense as were his victims. After being forced to settle a few lawsuits, it's unlikely a practitioner will continue to view the forensic engineering business as highly profitable. Steps professional engineers can take to address this issue are: meet and confer with other professional engineers who may share your concern about abuses in the forensic engineering business, to identify specific forensic engineers who are believed to be using the legal system for egregiously mercantile purposes. This effort may be initiated, for example, through informal conversations at engineering society meetings. Establish relationships with lawyers, particularly those with engineering degrees, to pursue contingent fee suits against such offending forensic engineers. Note that there are many underemployed and unemployed lawyers who will file a lawsuit on a contingency fee basis, no matter how specious the cause of action may be. The ensuing settlement may well result in not only a handsome fee for your partner lawyer, but a nice bit of compensation for your own time and effort. And this brings us to the conclusion of this brief discussion of ethical issues associated with the business of forensic engineering. I hope that this has been about what you were looking for and has been of some interest to you and may provide you with some food for thought moving forward. Thank you very much for letting me chat with you, and have a nice rest of the day.